Hello everyone, my name is Heidi Bourgeois. I am a foster care consultant with the Department of Children and Family Services. Today I have Margot Hammond, who will be presenting information on legal and custody information through the Kinship Navigator. So Ms. Margot, you can go ahead and begin.
Hello everyone. What we're trying to do here today is to give you some legal and custodial information that will be helpful for those of you who are kinship caregivers and for those professionals out there that work with kinship caregivers. Let me begin by saying that taking care of children on a full-time basis that are not your biological children is one of the most important jobs you'll ever have. And these children will always appreciate what you've done. Maybe not today, but sometime in their future. So you're going to run into a lot of problems as you begin to raise these children. And one of the problems you don't really want to deal with is the legal issues. However, you will be forced to do so. So let's start off by talking about custody. Many of us believe that once you have physical custody of a child, when that child is living with you, that is legal custody. In fact, that is not legal custody. In order to have legal custody of a child, you must do some type of paperwork. It may be at the court, it may be before a notary, it could be almost anything. So we're going to talk about the types of legal custody there might be out there. And of course, the first type of legal custody is what is natural legal custody. Who naturally has custody of a child? That's the mother, the father, if the mother and father are married when the child is born, or if the father has acknowledged the child. Both of these parents have certain legal rights and responsibilities to the child, and those legal rights can't be denied without a court order. The first thing we're going to talk about, as far as the different kinds of custody, there's a long list in Louisiana. I like to joke and say, you know, there's an old song that says, there's 50 ways to leave your lover. Well, in Louisiana, we know there's at least somewhere between 8 and 10 different ways to have legal custody. And these are the kinds we're going to talk about today. It could be provisional custody by mandate, voluntary transfer of custody, court-ordered kinship care, child in need of care, foster care, guardianship, adoption, custody granted in district court, and tutorship. There are a lot of factors that you need to keep in mind when you're deciding what type of legal custody is going to work for your family. You need to know what kind of authority you want over the child. Are the parents going to consent to this? Or are they going to fight you? What documents other people or other entities may require of you. You need to check if you don't own your home, you may need to check with your landlord or the housing authority where you work. You might want to check with doctors in regards to medical care, insurance companies, again, in regards to medical care. You need education is prime importance for these children. And it's important to check with the daycare or the school to see what documents they may require. You might want to check and see if you need child support, what documents you need in order to obtain child support, or what documents you may need to get other government benefits. What we want is for everyone to be a nice, happy family together, whether or not no matter what kind of custody you end up with. The first thing we're going to talk about is a non-legal custodian affidavit. This, in fact, does not really give you custody. It gives you some very limited authority over a child. The child has to be living with you, they cannot be in your legal custody, and they can't be a foster child. These decisions are only in regards to medical care and educational decisions. The parents can come in at any time and override your decision. It's only good for 1 year or until the child is no longer living with you. You can't prevent parents from visiting or removing the child from your home. The parents are still obligated to support their child, and there is a form that you can find in the Louisiana law that you can use for this. Again, I urge you that this is for very limited circumstances and does not give you legal custody, but authority to make medical and education decisions only. One of the most important things I can point out in regards to provisional custody by mandate is that most school districts will not accept this as authority to place the child in school. Even though the law says they should, they don't have to accept it, and most school districts will not accept it. The next custodial possibility is voluntary transfer of custody. This is a court-ordered transfer of custody, and it's done after there's a filing of a petition and there's a hearing in court. The petition is filed by one or both parents. You really do need the parents' cooperation in order to have this done. If one of the parents is not willing to sign or is not available, then that has to be pointed out in that petition. The court can appoint an attorney for the parents or for the child. The person who's getting custody is not appointed a lawyer, but they may bring one to court with them. The judge at that hearing can ask questions of the parents, the possible custodian, and of the child. Once the custody is ordered to you, you have the authority to have physical custody of the child, protect the child, discipline, provide food and shelter, enroll the child in school, and make medical decisions for the child. It's important to point out that, yes, if you have this court-ordered custody, school systems will accept that in order to enroll the child in school. The judgment is good until the child turns 18 or the court changes the order. The judge can, in fact, in that judgment, put in rules for visitation and for child support. If there are rules in there for either one of those things, you must follow those rules. If the judge says, for instance, that the parents can visit once a week, you can't decide that the parents cannot visit on those days. The only way that can be changed is by court order. Benefits that the child is receiving can be transferred to you, or you may be able to apply for benefits. Again, it's important to check with each agency for their recommendations. There are court costs involved in filing this petition, and those vary from court to court. One of the things in the petition that's required is that the custodian signs saying that they are willing to accept custody of this child, and that paper has to be notarized. Therefore, there may be a notary fee involved also. This form is available at many of the clerks of court, or again, in the Louisiana law at the Louisiana Children's Code, Article 1550. Once these children are in your care, you can see that they can be happy because they're with their families. The next thing we're going to talk about is when custody involves the state. Okay. Many of you may have heard of a proceeding called a child in need of care. And this happens when there is a belief that the child has been harmed or is at risk of harm due to abuse, neglect, or abandonment. The child can be removed from the home by the police or by the Department of Children and Family Services. The court has to decide whether or not the child can remain safely in the home. If they decide the child cannot remain safely in the home and it's in the child's best interest, then the court can order the removal. Please keep those words in your head as we talk about children who are in the custody of the state, is that all court decisions are based on what is in the best interest of the child and keeping the child safe. There are going to be multiple court hearings all the way from the very beginning, which the first hearing is held within 3 days, until the child is either returned home to the parents or adopted. There are always attorneys involved with this, as much as we may not like that. One will be appointed for the parents if they can't afford one. An attorney is appointed for the child, and there will be an attorney for the state, either the district attorney or an attorney from the Department of Children and Family Services. Another important point to remember is that the attorney appointed for the children has a very specific job, and their job is to represent the child's wishes. There are times when you will believe that these children should not go home, and everyone in the courtroom will believe that the children should not go home. But it is that attorney's job to put forth the child's wishes, and frequently, no matter what has happened at home, the children want to go home. Anyone else that may be involved in the case can hire their own attorney. If you're a grandparent or kinship caregiver, you may ask the court to allow you to come into the case. And in order to do that, it's going to be important for you to have an attorney. Okay, so this is the big red letter box. It's really important that as soon as you know that a child that you love or care for is in state's custody, that you contacted the Department of Children and Family Services. They want to know about you. They want to know that the children have a support system out there. Let them know that you're interested in having the child live with you, or even if you're simply interested in having the child maintain contact with you. Let them know. It's important if you don't come forward initially, you may not be considered for placement in the future. So even if you don't know if you can take the child now, let them know that you're there and that you're considering whether or not to take the child. So once the child is involved in the court system in a child in need of care case, one of the options for the court is to order the child into the custody of a kinship caregiver. And the child at that point would not be in the custody of the state if they give custody to a kinship caregiver. The court may give custody to any suitable person. It can be kin, or what we call fictive kin, meaning close friends of the family, maybe a godparent, maybe a neighbor, but those are people that the children think of as their kin. The home has to be safe and appropriate, and of course the law, as I said before, prefers for the child to be with kin. It's designed to be temporary, but cannot be changed until there's a court order that the child can return to their parents, the child is adopted, or the child turns 18. Once the custody is ordered to you, you have the authority to have physical custody of the child, protect the child, again, discipline the child reasonably, provide food, shelter, enroll the child in school. Again, you're going to have that court order, so that school has to take that court order and allow you to enroll the child in school. Make medical decisions. As far as visitation is concerned, in that judgment, the court may establish rules by which there is to be visitation between the child and their parents. You can come to an agreement with the parents on visitation, and usually the court is happy for you to do that and set up and put that into the court's order. But once it's in a court order, you have to follow those rules that are set up by the court. Child support, again, can be ordered by the court, or you may be able to apply through child support and enforcement, or you might have to hire an attorney and file with the court in order to get child support. Any benefits the child has can be transferred to you because, again, you have that court order giving you custody. Or you can apply for benefits. Check with each agency for whatever their requirements may be. There should be no paperwork or court costs on your part unless you hire an attorney separately. Please remember that there is a distinction between the court giving you custody and the court giving custody to the state and the state placing the child in your home. And that's what we're going to talk about now. We're now going to talk about foster care. And that is when the child is actually placed by the court in the custody of the state. And it doesn't make makes no matter whatsoever where they're living. It's still called foster care. It could be with kin, it could be with fictive kin, it could be in a certified foster home, or in a group setting like a group home. All of those are considered to be foster care as long as the child is in the custody of the state. Now, kin or fictive kin can become a certified foster home. And usually that's what the Department of Children and Family Services hopes for. DCFS will have to present a plan to the court for approval, and it includes where the child will live. Again, foster care is designed to be temporary, and it cannot be changed until there's a new court order, hopefully the child returning home to their parents, or the child is being placed under guardianship, the child is adopted, the child turns 18 years old. When they turn 18, their court involvement ends. However, if the child has been in foster care, that child may be eligible for further supports from the department until they reach age 21. If the child's in state's custody and is placed with you, you're going to be expected to do all those things we keep talking about. We say the same things over and over again. You need to protect the child, discipline the child, provide for their daily needs such as food, clothing, and shelter, ensure that the child attends school, transport and participate in medical appointments and school meetings, make the child accessible for confidential attorney-client visits. You should receive notice of every meeting and court date that involves this child. You need to share any information you have. You're with that child every single day, and you have more insight and information on the child than anyone else does. So it's important to speak up and provide any information you can to both the department and to the courts. As far as school and education is concerned, the department will provide you with any necessary paperwork in order to enroll the child in school. And unless it's an emergency, the DCFS caseworker should be consulted prior to any major educational decisions. Visitation must follow the approved DCFS plan. Now let's go back to those meetings. In that meeting, when they're developing that plan, they're going to develop a visitation schedule for the parents. You need at that meeting to let them know what may be good for you, what you think might be good for the children. There's no point in having the children scheduled for 3 o'clock visitation on a Tuesday when their favorite baseball practice is 3 o'clock on Tuesday. It's just going to make everybody unhappy. So it's important to let all that be known at that planning meeting. Once that plan is in place, then you have to follow that visitation plan. If there's any child support, it goes directly to DCFS. Benefits can also go to DCFS if they're already in existence. And if there's any to be gotten, then DCFS will help with that, that application process. At some point, it may be that the child is receiving both, let's say, Social Security benefits, and you are a certified foster parent. In that instance, it may be that the Social Security benefits are more than the foster care benefits. So it might be beneficial for you to receive the the Social Security benefits rather than the foster care payment. But that's something you should discuss with the worker, and they will help you make that decision. There should be no paperwork or court costs on your part, but again, you are allowed to hire your own attorney, and you may be able to, it may be that you make a decision that you want to be a party to the court proceedings. If that's the case, you need to hire your own attorney so that you can step into that court case. But you don't have to. Keep that in mind. If everything's going the way you want it to be going, then there's no need to get anybody else involved. The next type of custody that requires that there's a child in need of care proceeding, and that, in fact, the state has taken custody at some point in time, is guardianship. Let me make it clear that under guardianship, there must be a child in need of care case, but the child doesn't have to be in foster care. They may be in foster care, but they don't have to be in foster care. Okay. This is the only time that word guardian is used in Louisiana legally. It's used in a lot of law, but it's very confusing to people because in Louisiana, generally speaking, it is not used. But it does refer to a person who has legal authority over a child. It can only be granted in a child in need of care case, and then the judge has to decide that reunification or adoption is not in the child's best interest, even though that's what we usually want for children. The child has to have lived with the guardian for at least 6 months. They will do a home study and make a report to the court on the potential guardian. It is designed to be permanent. You know, we talked about other forms of foster care not being permanent. This is designed to be permanent. It can only be changed by court order. The guardian, and then only if the guardian no longer wants to serve or cannot serve, or the guardian is no longer in the child's best interest. The guardian is going to have authority to have physical custody of the child, again, protect the child, discipline, provide food and shelter, enroll the child in school. You're going to have that court order to take to the school. You can make medical decisions. You can also consent to marriage and an enlistment in the armed forces. The one thing you cannot consent to is adoption. Visitation has to be addressed in the judgment of guardianship, and you have to follow those rules. Child support can be put in the judgment, but you can also apply through child support enforcement. You might need to hire an attorney and file with a court. If the child has been in foster care for at least 6 months prior to the time that there's a guardianship judgment, there can be an approval for a guardianship subsidy. If you wish to have a guardianship subsidy, it has to be approved prior to the guardianship judgment. Other benefits can be transferred to you or you can apply. And again, you need to check with each agency for their requirements. There should be no paperwork or court costs on your part unless you decide to hire your own attorney. Again, you don't have to, but if that's a decision you make, it's going to be a cost to you. And our families are made up of all kinds of people, young and old, boys and girls, and every color of the rainbow. The next thing is adoption. Now, not every child is adopted from foster care, and that's why we put a break here. And we need to talk about what adoption is. Really and truly, the easiest way to think about adoption is that we are forming a new legal family, just as if those children were born to the adopted parents. In order for that new legal family to be formed, the parental rights have to either be terminated, meaning that there's a petition filed for the termination of parental rights in the court, and the court determines that there is grounds to involuntarily terminate the parent's rights. Or the parents decide on their own that they cannot continue to raise the child, and they voluntarily surrender their rights. This is a hard decision for people, and it's one to be respected. But one of these two things has to be done. So the parental rights either have to be terminated or surrendered prior to the time the adoption petition is filed. There are different types of adoption. The three types of adoption are agency adoption, which may be something like the Volunteers of America or a religious group, but this includes the Department of Children and Family Services. Intra-family adoptions are between members of the same family, and that may be where kinship caregivers begin their adoption process. Then there are private adoptions. Private adoptions are usually done through an attorney and are much more complicated. In every case, there's a home study of the potential adopting family. And the law requires that it has to be a safe, secure, and loving family. That home study is done by a social worker. That social worker, in turn, gives that home study to the court. The petition has to be filed with the court. The court has a hearing on the petition. If the court approves, the child's going to become the legal child of the adopting parents as if they were born to them. Adoption lasts a lifetime. Once a child is adopted by you, they're your child for the rest of their lives. Is an attorney necessary? Absolutely. This is a very complicated process. The law requires reams of paperwork, and it's really important for all of it to be done right. If it's not done right, the adoption can be overturned, which will be heartbreaking to the adopting parents and to the child. There are court costs that are involved with every one of these petitions, and they vary from court to court. If the child is in DCFS custody when you adopt, there may be some limited financial aid available to cover legal fees and court costs. The adopting parent has the same duties and obligations of any parent, any biological parent. Remember that once this child is adopted, they are the adopting parent's child. There is no other parent at that point. As far as visitation is concerned, generally speaking, the adopted parents decide. You need to consider whether or not the child has positive connections, maybe with cousins or aunts, or even siblings who have been placed or adopted elsewhere. Before the judgment of adoption is rendered, you can come to a continuing contact agreement with other family members, or maybe even with a prior foster family or visiting resource for the child. Again, those positive connections are very important for the children. Biological parents are allowed visitation, but it's under limited circumstances. And again, it needs to be in that judgment of adoption. As far as support is concerned, the parents are no longer obligated to support the child in any way. If the child is in DCFS custody, they may be eligible for an adoption subsidy. If they are, in fact, eligible for an adoption subsidy, it has to be approved prior to adoption. Inheritance rights are really important and a little bit different when it comes to adopted children, because adopted children not only have the right to inherit from their adopting parents, but they also have the right to inherit from their biological family. This is one of those things that when you are talking to the attorney who is doing the adoption, you should ask about, and they should fully explain to you what the child's inheritance rights are. As far as benefits are concerned, you can apply and transfer any benefits the child is receiving. Once the child is adopted, they are your child, and you have authority to do anything that is necessary for that child. Now, it is important that if the child is receiving benefits when they are adopted, you must notify the agency of the adoption. This may put a limit on the benefits the child is receiving based upon your income, but on the other hand, it may allow the child to get some additional benefits because of things you're eligible for. There's another way that you can obtain custody of a child. It can be granted through a district court when the state is not involved. Usually you think about this when people are getting a divorce or a separation. But this is also available to non-parents when there are problems in the family. The custody can be given to a non-parent when custody to either parent will result in substantial harm to the child, and the non-parent can provide a wholesome and stable environment. And this can be any person. It doesn't have to be a biological relative. Again, we can talk about fictive kin here. There's a lot of paperwork that has to be submitted to the district court. There's a hearing. Again, those magic words, everything has to be decided in the best interest of the child. This judgment would last until a court ordered change in the judgment or the child turns 18. There are ways to get temporary custody through the district court. Again, there's paperwork with specific information that you have to fill out and specific allegations you have to make about those parents. Many courts have the forms available for you. They might be online or at the courthouse. Some of the courthouses even have self-help desks. We will have on our website links to some of these resources. The parents have to be served. It's only good for a limited time period, after which there must be a hearing. In this process, attorneys can be very helpful to you. It is a complicated process. There's specific paperwork that you have to do. The court costs vary from court to court. Sometimes you can file what they call an informa pauperis petition. That would allow you to file, depending on your income, without paying court costs immediately. However, you will eventually have to pay those court costs. And some courts will let you pay a little at a time, but some want their money all at the same time. Your duties and responsibilities are the same as any biological child you may have. Visitation and support, the court that gives you custody should address both visitation and support. And those benefits, again, can be transferred to you or you can apply. And check again with the agency for the requirements. Okay, the next thing is tutorship, which is really a confusing concept. In most states, tutorship is called guardianship, but that's not what we call it in Louisiana. Remember what I said earlier about guardianship. Guardianship in Louisiana is a term for custody only in a child in need of care case. So a tutor in Louisiana is legally responsible for caring for a minor child by court order. I know it's confusing because there's times where you will see that word guardian or guardianship all over Louisiana law. But the only time it means anything is in the child in need of care case. That's when it gives you custody. So in Louisiana, in order to be a guardian, you have to be a tutor. And it's used primarily when both parents are deceased, the parents are divorced, or the parents are unable to care for the child. But most frequently, it's used when the child has money, because somebody's got to be able to manage that child's money. A non-parent can be appointed, but they usually appoint a parent to be a tutor. But they will appoint a non-parent if they're named in the parent's will. If none are named, then they're a close blood relative. If none are named in the will, then both parents are deceased, and there's no close blood relative. Petition has to be filed in the district court. It has very specific information that needs to be submitted. Again, got to be in the child's best interest. And the court will then issue what's called letters of tutorship, which is like your judgment that you take to places to tell them that you're the child's tutor. They will also appoint what they call an undertutor. And that undertutor's job is to keep an eye on the tutor and make sure they're doing right by the child, both taking care of their physical needs and taking care of their monetary needs. The person who's named tutor must accept the appointment. They have to post security that equals what the child owns. So if, for instance, if a child has been involved in an automobile accident and they get a settlement of $100,000, then the tutor has to post security or a bond that equals that amount of money. Tutorship would last until the child turns 18. The only time it goes past 18 is if prior to 18, the court finds that the child has a serious developmental disability. It will also end if the child is emancipated, meaning that they are made to be an adult before they turn 18. The court can change the tutor. If they find that the tutor is not acting in the best interest of the child, then they can change it at any time. Is an attorney necessary? Yes, indeed. It is a very complicated legal process. Again, if the paperwork is not done right, it can be found to be invalid. And this is important. If the child thinks you acted improperly, or if you filed for a tutorship improperly, the child has until age 22 to sue the tutor for any damages they may have had from that. The court costs are going to vary from court to court. The duties and responsibilities of the tutor are placed in the court order, which may include the care and custody of the child, including medical decisions, properly raising and educating, managing anything the child owns. Again, if they own anything, remember, you're going to have to provide a report to the court on how that money is being spent. Visitation and support, that depends a lot on if there are any previous court orders. And you should consult the attorney you've hired to do the tutorship to help with that. And again, benefits can be applied or transferred based on the court's order. Birth certificates. So we're going to start talking about some things that are a little different than custody, and we're going to begin with birth certificates. And I show you this little birth certificate in the corner here to tell you that it's cute, but it doesn't get you anywhere. You need a certified birth certificate. And there are only certain people who can get a certified birth certificate. It's the actual person on the document, their current spouse, their mother or father, their adult child, their adult sister or brother, their grandfather or grandmother. So that helps a lot of kinship caregivers. If they're old enough to have a grandchild, their grandchild can get it, but I don't think we'll be talking about any young people like that. An attorney who represents any of those folks can also get a certified copy of the birth certificate. But this is important, any other person with a judgment of custody. So for instance, let's go back and look at that voluntary transfer of custody. That would allow you to get a birth certificate. A judge in a child in need of care case who places the child in your custody, that would allow you to get a birth certificate. but that provisional custody by mandate will not let you get a birth certificate. There must be a judgment of custody. You have to go in with identification, and you can either have one primary, which is the usual things you think about, like driver's licenses and military IDs and passports, or two secondary. If it's a college student, they have to have their fee paid receipt for the current semester, a Social Security card and a W-2, original adoption papers, certified title to a property, and so on. How do you get a birth certificate? There's a number of different ways. You can go in person to the Vital Records Central Office, which is at the Benson Tower in New Orleans. Some clerks of court can issue birth certificates, but there's some additional fees that apply then. There are also Vital Records kiosks in certain places, and again, you have to pay a little extra fee to get them at those places. But it may be cheaper than paying for parking in New Orleans. You can also get them by mail, through the internet, fax, or telephone. And again, there's a little extra fee for using that service. Now, for children who are in the custody of the state, the Department of Children and Family Services will provide a birth certificate for those children. So we've talked about a lot of papers. So let's talk about what are important papers. Birth certificate. Any document that authorizes you to have custody or act on behalf of the parents. That could be that voluntary transfer of custody order. It could be the provisional custody by mandate. Anything at all that authorizes you to have custody or act on behalf of the parents. That's an important document. You should make copies of these of your certified documents. Remember, we talked about a birth certificate that's certified. Those judgments are also, or your mandate is also certified. Make a copy of those. Carry the copies with you. Never give up your originals. And make sure you hang on to those originals in a safe place. Okay, we're going to talk a little bit about health care. And it's interesting in Louisiana, consent to health care does not necessarily require a parent. It can be the parent or anyone who's caring for the child. Believe it or not, Louisiana allows minors to consent to their own health care. For children in DCFS custody, if they're living with you, you should consult with their worker unless it's an emergency. If it's an emergency, you take them to the nearest hospital. As far as medical expenses are concerned, caregivers are responsible for that child's medical expenses. Now, if you're a kinship caregiver, there's a possibility that your health insurance can be extended to the child, but you need to talk to your health insurance company about that. The child may be eligible for Medicaid or CHIP. If children are in DCFS custody, they are going to receive Medicaid, and you will get a Medicaid card to them automatically. Who can actually apply for Medicaid? Well, a parent can, any court-ordered custodian. Remember, if you have that court order in your hand, that helps you. Someone who's claimed the child on their income tax, someone acting for the applicant. So once again, that's pretty broad, allowing you to apply for Medicaid. They will tell you specifically if your circumstance does not allow you to apply. How can you apply? You can do it online, you can do it by phone, you can do it in person, or you can even do it by mail. For kids that are under 5, they may be eligible for WIC benefits, so that's important to find out about. And those WIC benefits do have some income and residential requirements. Again, you can apply online, or you can call this really easy number, 1-800-251-BABY. I like that one. So where do you want to find health services? You can find any health care provider who accepts the child's insurance. If the children are in DCFS custody, they're going to be enrolled in a specific health plan, and their worker will know what that health plan is, and they will inform you of what the health plan is. And anytime they have, again, non-emergent care, you need to contact the worker, but if it's emergency, go to a hospital or the nearest healthcare facility. Who can the doctor talk to and who can see the records? Well, the parents certainly, the person caring for the child, and there's a few exceptions. The child can refuse disclosure. Person appointed to direct the child's health care can refuse disclosure. There'll be no disclosure if the health care provider and the parents agree to the relationship between the child and the provider. The last area we're going to talk about is mental health care. Mental health and substance abuse care is a little bit different than regular health care. There are very specific laws that apply to mental health and substance abuse care, and they are different from the usual health care laws. There are two types of treatment for mental health and substance abuse. One is voluntary treatment and one is involuntary treatment. Voluntary treatment can be consented to by the parent or the tutor. If they're not available, then by a caretaker. So this kinship caregiver would be considered a caregiver. Foster parents, a legal custodian, or a person providing a residence for the child. 16 and 17-year-olds can consent for their own treatment. I call them older teens, just to make things easier. Now, if a child is brought into an inpatient treatment facility, who can object to them being there? Well, the parent, the tutor, or the caretaker, or that older teen can, okay? Within 72 hours of that objection, the facility has to start involuntary procedures. So that's the other way a child could be placed in a treatment facility, involuntarily. And usually that can start with what's called an order for protective custody. And that's an order that you would go to a coroner or district judge, and usually it is the coroner, and tell them that the child is in need of mental health care and they may be a danger to themselves or others. At that point, the coroner or district judge can issue an order that the police will then use to take the child to a treatment facility for an evaluation. Once they're at the treatment facility, they have to decide whether or not the child should be admitted. If they decide the child should be admitted and no one will allow the child to be there voluntarily, then the doctor can do something called a physician's emergency certificate. It's good for 15 days, and within the first 72 hours, a coroner, who's usually a psychiatrist, will also come out and see the child to do another certificate. The next step is if the child needs to be there more than 15 days, then someone has to file a petition for judicial commitment. That petition is filed with the court having juvenile jurisdiction. There's a hearing. The court has to find that the child is a danger to himself or others or gravely disabled. Discharge is then up to the court or the doctor. And one of the important things for you to remember, the child will not get treatment past the time the doctor feels the child is ready for discharge. And filing a petition for judicial commitment will not necessarily get a child's treatment. As far as communication is concerned with the treatment facility, for voluntary patients, the law requires that the facility communicate on a regular basis with the parent or guardian. Oh, there's that word guardian again. And any safety issue that arises requires notice within 2 hours. Involuntary patients, there are no requirements, but there is also no restriction on communicating with the parents or the caretaker. Parents and tutors are permitted access to medical records. The older teens can object, and there's special rules for substance abuse records. Now, as far as attorneys are concerned, only the children are entitled to representation, and it's by the Mental Health Advocacy Service. And again, remember, those attorneys that represent the children have to represent the child's wishes. Anyone else has to hire their own attorney. If you think that your family member is in need of mental health treatment, here's a list of things you might be able to do. If it's life-threatening, always call 911. If they're Medicaid eligible, there are numbers for that. There's a crisis support number for the whole state. And if they're covered by private insurance, you may want to contact the health insurance or consult with the child's pediatrician or physician. For information on state services, you can go to the state website for the Louisiana Department of Health. If you want more information than what we've given you here today, especially some of these links, please go to www.dcfs.la.gov and follow the link to child welfare. I am relative. Thank you.
This concludes our portion for today. This link will be posted on the DCFS website. If you need any additional information, please reach out to us. Thank you.